afternoon. My name is Laura Raisty. I'm one of the employment attorneys here at Kenny and Sam's, and I am joined today by my colleague, Brittany Darcy. And we are here today to talk about the interactive process for reasonable accommodations. Postponed from yesterday, but we're glad that you could join us here today. Employers are required to engage in an interactive process when an employee requests a reasonable accommodation for a disability or for a sincerely held religious belief. An understanding of this process is very important for employers to mitigate risk, avoid legal liability, and promote an inclusive workplace. So today, Brittany and I are going to examine the interactive process, hopefully shed some light on what is often a complicated topic for employers and human resources folks, and go over some best practices to ensure that you are best able to navigate the process, including training, documentation, and confidentiality. And with that, I'm going to hand it over to Brittany, who's going to start by giving us some background.
Thanks, Laura. Before we dive into the reasonable accommodation process, we thought it would be helpful to help everyone understand the reasons that this is in place and some of the things to know as an employer or an employee if the situation arises. So as you may know, the ADA protects against discrimination of qualified individuals who have disabilities. The state law, General Laws, Chapter 151B, is largely analogous, and so that also prohibits against discrimination of individuals who have disabilities. The ADA applies to employers with 15 or more employees, and that includes state and local agencies, employment agencies, and labor organizations. The state law covers employers with 6 or more employees. Both the ADA and Chapter 151B apply to both applicants and employees. So it's important to keep this reasonable accommodation process in mind as you are dealing with applications for a new job. An employer is required to make a reasonable accommodation to the known disability of a qualified applicant or employee if it would not impose what's considered an undue hardship on the operation of the employer's business. Now, 3 important definitions to keep in mind as we're walking through this process is what constitutes a reasonable accommodation. And that is a modification or adjustment to a job, the work environment, or the way that things usually are done that enables a qualified individual with a disability to enjoy an equal employment opportunity. An equal employment opportunity is the opportunity to attain the same level of performance or to enjoy equal benefits and privileges of employment as are available to an average similarly situated employee without a disability. And an undue hardship is an action that requires significant difficulty or expense when considered in light of certain factors like an employer's size, its financial resources, the nature and structure of its operation, and the nature and costs of the accommodation.
One thing I should have said at the beginning was we're first going to address accommodations of disabilities, which is where Brittany started. And then at the end, we're going to cover religious accommodation and highlight where that's different from disabilities. But we're going to start with accommodating individuals with disabilities. As Brittany alluded to a couple moments ago, covered employers must provide effective and reasonable accommodations in a number of different aspects of employment. First is the application process, and then there is also the actual employment, when your employee is working for you to enable them to perform their job. And then lastly, to have the ability to enjoy the equal benefits and privileges of employment. So we're going to break that down a little bit right now. To ensure equal opportunity for disabled applicants, you need to make your application process, you need to ask during your application process if there's any reasonable accommodations required for the applicant to participate in the process. And you need to also make sure that your application procedures are accessible for any applicants who may be disabled. Um, the ADA does not require employers to develop or maintain job descriptions, but the EEOC, which is the Equal Employment Opportunity Commission, which is the federal agency charged with monitoring and ensuring compliance with the federal anti-discrimination law, advises employers to include information about the essential functions of the job in job announcements, advertisements, and other recruitment notices, because that information is going to enable applicants, including individuals with disabilities, to know that this position is appropriate for them. To ensure that they have the qualifications to perform those essential functions. Ultimately, the ADA requires that an individual with a disability's qualifications for a job be evaluated in relation to those essential functions. With regard to the application processes, I think most employers or many employers now have online job applications. You need to make sure that those are accessible to folks with disabilities or provide an alternative means for those people to apply for jobs. Again, unless you can show that making those alternative arrangements causes an undue hardship. What does this mean practically? If you have a video or audio content in your job application, you should provide a transcript of that or some alternative means so someone can read the content of that video or audio. You want to make sure that it's navigable, not just using a mouse, but also using a keyboard. The keyboard is a very important tool for folks with disabilities, and it's how they navigate a lot of different computer-based platforms and applications. Also, color contrast, and for people who are visually impaired, you want to keep that in mind. Organization is also important. Use headings, use bold, things like that are important. When you get to the interview stage, you want to make sure that if you have a disabled person who requires a reasonable accommodation, that they're provided. What might this be? An accessible location for people with mobility impairments. For instance, if your second floor is only accessible via stairs, but that's usually where you do your interviews, you may need to do your interview on the first floor so someone with a wheelchair can access the facilities. You may need to consider a sign language interpreter for somebody who has a hearing impairment, a reader perhaps with someone who is visually impaired. And if you require testing or timed testing for your applicants, you may want to consider whether a modification is required for someone who may have a learning disability. Then we get into post-offer inquiries and examinations. Employers can use these for all employees. And you should be if you're using them for disabled people, you should be using them for all employees. You certainly don't want to be singling out disabled folks for particular testing, but you are allowed to use that testing to determine if an employee can perform the essential functions of the job with or without a reasonable accommodation. However, keep in mind that under applicable law, those tests must be job related and consistent with business necessity, and the scope of that inquiry needs to be limited to job related functions. Next, after the application process, we get to what kind of accommodations are necessary for a disabled individual who is your employee. Again, if employers need to provide reasonable accommodations to enable qualified individuals holding the job to perform the essential functions of that job. Now, there are no specific policies that are in place for employers when they're trying to accommodate a disability, but you want to make sure that we're going to get to it, but you engage in the interactive process. If somebody tells you, I have a disability and it's impacting my ability to perform these functions of the job, that ticks off your obligations to have a conversation with that employee and to take additional steps about what that reasonable accommodation might be that will enable them to perform the essential functions of the job. And we're going to dive into that in a little bit more detail in a few minutes. Finally, you want to be able to enable an employee with a disability to enjoy the equal benefits and privileges of employment. What does that mean as a practical matter? For example, if you have non-work facilities that you maintain for your employees, like cafeteria or company provided transportation, you must make sure that those facilities are also accessible to your employees with disabilities. Um, or if making that facility accessible would be an undue hardship, you should provide a comparable facility for the person with a disability. Another example of making accommodations to allow disabled employees to enjoy equal benefits and privileges of employment would be making an adjustment to a training or a workshop so that a visually impaired employee can enjoy full participation in that. Um, if a disability, now we're going to start talking about the interactive process. If an accommodation is obvious, you may not, the interactive process may be obviated. You may not need to do it. For example, if someone is in a wheelchair and in order to get them at their desk, the desktop needs to be raised, that's fairly obvious. You just raise the desktop. You've now provided the reasonable accommodation, and you sort of need go no further. But when the accommodation is not obvious, it's best achieved, and in fact, you're legally required to engage in an interactive process. This interactive process should not be antagonistic or it's a cooperative effort to allow your employee to perform the essential functions of their job or to enjoy the benefits of privileges of employment. Um, so, why do we do this? Number one, as I just said, it's required by law. Number two, you want to make sure that you attract good talents, and the talent is out there in many shapes, sizes, and different folks. So you want to make sure that you're allowing those folks to perform at their best. You want to retain your experienced employees, your good performers that may encounter a condition that might render them disabled for any period of time. Finally, a lot of accommodations are fairly straightforward and they're not very expensive to do. That's not to say that all of them are that way, but you want to engage in this process so you can identify what accommodations that may not be too much skin off any employer's back that you can allow your employees to perform at their best.
And to ensure that your employees can perform at their best, and also to ensure that the right people are able to recognize when that reasonable accommodation process should begin, it's important for employers to have practices and policies in place that set them up for success. And so, in order to ensure compliance with the ADA and Chapter 151B, before a reasonable accommodation request or even suggestion arises, it's helpful to develop written accommodation policies and procedures. Keep it simple, keep it flexible, keep it straightforward. But that way, there is some sort of process by which the managers in the arena understand what should happen if there is either a direct request or perhaps a question as to whether a reasonable accommodation is necessary. It's important also that employers notify applicants and employees of its obligation to provide these reasonable accommodations and train managers and supervisors to recognize when accommodation requests arise. And it's also important to understand that there's a duty to provide a reasonable accommodation if the employee identifies himself or herself as a qualified individual with a disability. It does not necessarily mean that the employee has to directly request such an accommodation. The employer may still have a duty to offer one if the employer knows or should have known that the employee requires it. And if the employee is having difficulty performing his or her job and the accommodation is not obvious, the employer can ask if a reasonable accommodation is necessary. And so in crafting that reasonable accommodation and trying to determine what it might look like, the employers should first analyze the particular job that's involved, determine what the essential functions are. That will really help inform the process about what type of reasonable accommodation may be best for this employee. It's also very important to ensure that you're consulting with the individual who has the disability to determine the precise job related limitations that are imposed by that person's disability and how those limitations might be overcome with a reasonable accommodation. When you're discussing how this reasonable accommodation might work, it's helpful to identify multiple possible accommodations and assess the effectiveness of each. That way, you're not simply tied to one accommodation only. And if you later learn that accommodation will create an undue hardship, for example, then you're back to square one. So, identifying multiple accommodations helps avoid that problem later. And also, it's important to consider the preference of the individual who is being accommodated to select the appropriate accommodation. Now, with that being said, as we will discuss later, the employee's preference is not necessarily determinative, but it is important to be aware of and understand as you are working through the reasonable accommodation process.
So the first step in the process is that you need to recognize when an employee has made a request for a reasonable accommodation. According to EEOC and relevant case law, there are no magic words that require this. The employee does not need to approach you and say, I have a disability and I need a reasonable accommodation. They can use plain English. They need not reference the law or use the phrase reasonable accommodation. But if an employee comes to you and says, I'm having issues with X because because of this issue, that may be a request for a reasonable accommodation if the issue is potentially tied to something medically related or related to a disability. If you're not sure whether your employee is asking for accommodation, you want to ask clarifying questions. What exactly are you requesting and why? When you've determined that you have gotten a request for a reasonable accommodation, it's a good idea to assign an employee to sort of be the point person for that request to make sure that it doesn't get lost in the shuffle and that the employee knows who requests should be made to. One thing to be aware of, there is a fairly notable case out there that an employee kept falling asleep at their desk. And just the knowledge of seeing this employee falling asleep at their desk was held to put the employer on notice that this person might require a reasonable accommodation. So sometimes it's not just what people come to you and are asking you about, but it's what you observe. And so simply what you see might put you on notice that you should start a potential reasonable accommodation process. Next, after you get the request, you want to gather information, ask questions of the employee. What exactly is the problem? How would you solve this problem? What do you think that you need? You need to know specifically what the limitations are on specific job performance criteria or specific work tasks. Obviously, the folks with the disabilities are more familiar with their potential limitations than you are, and will likely know what accommodations will work best for them. In certain circumstances, you can also ask for medical documentation or a doctor's opinion on what would be the best accommodation to perhaps give an employee. However, you want to keep in mind that confidentiality here. You don't want to ask more than you need to know from any medical doctor. Limit it to what the doctor believes is required, and use that as to assist you in identifying potential effective options to accommodate the employee. Again, although the ADA limits the scope of medical requests, it does not include specific forms for requesting that. So when you do request that, you want to make sure that, again, your forms are narrowly tailored to address the issue before you. And again, keep in mind the importance of confidentiality when dealing with employee medical records. It's also going to be helpful to know over time if the employee's limitations are predictable, subject to change, stable, progressive. While that information may not always be known, when available, it can be helpful in selecting an accommodation. Um, Next, you want to explore the options. Again, talk to the employee. Look at the medical information that you may have obtained from the doctor. Keep in mind, however, that the doctor is not making employment decisions for you, or deciding whether or not a reasonable accommodation can or should be made. That is the employer's prerogative. Consult with outside resources where appropriate. I'd suggest to you that it might be helpful to consult counsel to make sure that you are, doing the process as robustly and as thoroughly as you can.
And after you've undertaken what's hopefully a very robust process, you're at the point where you're going to choose an accommodation. Now, that accommodation is going to be made at the employer's expense. And so, as we mentioned earlier, it's not necessarily the accommodation that the employee directly requests or prefers. However, that should be taken into consideration. If there's more than one option and the employee's preference is a good one, then certainly you can go with it. But you are not required to provide, as the employer, the best accommodation available that the employee necessarily requests. And the employer may select the most cost-effective accommodation so long as it's a reasonable one. It's also important to keep in mind that the reasonable accommodation does not have to be a permanent one. The employer can try out accommodations and determine which one is the best fit with the input of the employee. And so in that sense, it may be helpful to consider a written agreement that specifically outlines what the trial period for that reasonable accommodation test might look like. This way, there's going to be no surprise on either the part of the employee or the employer if there's a decision made that the reasonable accommodation that was initially selected perhaps is not the best fit. In the written agreement, you may want to consider outlining how long the trial period will last for and what will happen if the reasonable accommodation that's initially implemented does not work. Some examples of accommodations would be making the existing facilities accessible, restructuring a job, modified work schedules, acquiring or modifying the equipment that you have, changing the tests that are in place, providing qualified readers or interpreters, or reassignment to a vacant position. But it's also important to keep in mind that a reasonable accommodation does not include removing or reallocating essential job functions, creating new jobs, or providing personal need items such as eyeglasses or mobility aids. And so while it's at the employer's expense, there are limitations on what that expense should look like. But the accommodations that I just indicated are not necessarily prohibited. Ultimately, it is the decision of the employer. Once you've chosen the accommodation, you need to implement it. If there is equipment that is involved, it's important to ensure that it's properly installed because the employee also needs to be able to use that equipment and it needs to be functional. To that end, the employee and the employer should both be trained on the proper use to the extent that training is necessary. If the accommodation involves a schedule change or there's a policy modification, then the managers or supervisors who are involved in implementing that schedule or policy should also be made aware. Now, to Laura's point earlier, you want to keep this narrowly tailored. You want to only inform those who really need to know the information about the modification in order to implement it. If the accommodation involves an outside service, then someone needs to make sure that the service is provided promptly and effectively. It is not good to drag your feet on these things, and it's important to engage in a robust process, but to move it along efficiently and effectively. And finally, if the accommodation is a reassignment, then the employee may need time to acclimate to the new job, and that should be taken into consideration as well. Again, this may help where there is a written policy in place about the trial period for the accommodation so that there are no surprises if it doesn't end up working out.
And then after you've implemented the accommodation, you want to continue to monitor it to make sure that it is being effective and also not resulting in an undue hardship on the employer. changes can occur over time that cause the accommodation to be less effective or ineffective for um, various reasons, including, exacerbation of a disability, or perhaps it goes away, changes in workplace equipment, changes in the job, the facility changes, you move offices. And also, again, as I said, is it becoming an undue hardship on the employer? As Brittany alluded to a moment ago, you also want to make sure that if this involves equipment, that equipment is properly maintained. Most important, however, is keep the lines of communication open. Um, Employees who are receiving accommodations need to understand that they should let their employers know if there are changes or problems with the accommodation and who to specifically contact. In addition, check in with the employee, ask questions. Is this working out for you? Is it not working out for you? It's still part. There's the interactive process doesn't necessarily put a pin in the process and end it. You want to continue to ask questions. Being sensitive to the time, I'm now going to turn to religion, which has a few different points. Employers also have an obligation to provide reasonable accommodation for an employee who has a religious belief that conflicts with a job requirement, unless doing so would be an undue hardship for the employer. Importantly, the definition of undue hardship in the religious accommodation context is different from its definition in the disability context. As a reminder, a determination of undue hardship in the context of disability is based on factors including the nature of the accommodation, the cost of the accommodation, financial resources of the employer or the facility, the impact on operations. In the context of religious accommodation, an undue hardship is anything more than a de minimis difficulty or expense. So that's a much lower bar than when you're dealing with a disability. But you want to bear in mind, both for religious accommodations and for disability, that the burden of proving an undue hardship always rests with the employer. In considering a request for reasonable accommodation for a religious purpose, keep three questions in mind. Number one, is the employee's belief or practice religious in nature? Think about when employers were implementing mandatory COVID vaccines. A lot of employees were objecting to that, but when you dug down into it, was the objection to that really religious? A lot of times it was political. A lot of times it was philosophical. Also, a social belief is not a religious belief. A personal preference is not necessarily a religious belief. Keep in mind that something that might be religious for one person might not be religious for another. For example, working on a Sunday. Next, you want to ask, is the employee's religious belief sincerely held? Typically, I advise employers not to look too deep into that issue, because you can have a church of one. I could have the Church of Laura. I could be the only observer of the Church of Laura, and I can come up with, what my beliefs are and what my religion requires. But again, you want to keep in mind something that COVID taught us, which is that, I think a lot of employees have now realized that requesting a religious accommodation may get them out of doing things that they might not particularly want to do. But when you looked at some folks who were claiming, the one that comes to mind is during COVID, when people were objecting to getting the vaccines because they claimed it was as the result of fetal cell harvesting, which I think number one was pretty clearly shown to be not true. But number two, if they've gotten vaccines before or even taken over-the-counter medications, those were manufactured the same way as the COVID vaccine. So, if you're only objecting to the COVID vaccine and not these other ones, is that really a sincerely held belief? Finally, however, you want to consider whether the accommodation will involve more than a minimal expense or disruption for the employer, because if it will, then you may have an undue hardship. Examples of common religious accommodations: exceptions to the dress code, a Jewish man who wears a yarmulke, a Muslim woman who wears a hijab. Those are very, very common, minimal expense or disruption. A Catholic who needs Good Friday off to attend Mass, a schedule that allows for daily prayers at prescribed times for Muslim employees. Um, Let me give you some examples of accommodations that do impose more than an undue hardship: violating a seniority system, causing a lack of necessary staffing, jeopardizing security or health, costing the employee more than a minimal amount. Keep in mind that infrequent payment of overtime to employees who substitute shifts is not considered an undue hardship, nor is customer preference or coworker disgruntlement. Those also do not justify denying a religious accommodation to your employee. Again, as with any request for accommodation for a disability or for a religious belief, it's important to evaluate everything on a case by case basis, and you want to train your managers accordingly.
Thanks, Laura. We hope you'll join us again, whether it's to hear more from the Church of Laura or maybe to hear more about employment issues. Our next session will be hot employment issues in our construction law series, and that will go forward on January 19th at 7:30 a.m. Have a cup of coffee ready. And after that, on February 8th at noon, you can join us again to learn more about arbitration provisions in employment agreements. Thanks so much.